State of Wisconsin, Circuit Court, Manitowoc County, Branch 1. State of Wisconsin, Plaintiff versus Stephen A. Avery, Defendant. Arraignment and Motions, Case Number 05-CF381. Date, May 3, 2006. Before Honorable Patrick L. Willis, Circuit Court Judge. Appearances: Kenneth R. Kratz, Special Prosecutor, on behalf of the State of Wisconsin. Thomas J. Fallon, Special Prosecutor, on behalf of the State of Wisconsin. Norman A. Gahn, Special Prosecutor, on behalf of the State of Wisconsin. Dean A. Strang, Attorney at Law, on behalf of the Defendant. Jerome F. Buting, Attorney at Law, on behalf of the Defendant. Stephen A. Avery, Defendant, appeared in person. Transcript of Proceedings, reported by Diane Teschneck, RPR, Official Court Reporter. The Court. At this time, the Court calls State of Wisconsin versus Stephen Avery. This is case number 05-CF381. We're here this morning for an arraignment on the amended information in this case, and also to hear a couple motions that have been filed by the defense. Will the parties state their appearances for the record, please? Attorney Kratz. State of Wisconsin appears by Calumet County District Attorney Ken Kratz, appearing as Special Prosecutor, also appearing as Tom Fallon from the Department of Justice. Attorney Strang. Good morning. Steve Avery is here and in custody, Your Honor. Dean Strang and Jerome Buting appearing on his behalf. The Court. All right. The Court will first take up the arraignment on the amended information. Has the defense, I believe the defense has previously received a copy of the amended information, but I would like to confirm that at this time. Attorney Strang. That is confirmed. The Court. And Mr. Strang, do I understand that before proceeding to take a plea, the defense had a motion regarding the information? Attorney Strang. Your Honor, the defense does. I confine my remarks to the 3 new counts in the amended complaint and then reiterated or repled in the amended information. That is, first-degree sexual assault, the kidnapping, and false imprisonment. As to those 3 counts, the amended complaint demonstrated no probable cause, and therefore that amended complaint established no personal jurisdiction. I moved to dismiss it. The Court denied the motion. I renew the motion here now, understanding that the Court has ruled. We then requested a preliminary examination on the 3 new counts, all 3 of them felonies. We were not afforded the preliminary examination. I object to that. Further, I move to dismiss the amended information because there is no personal jurisdiction over Mr. Avery as to the 3 new counts. So the 3 new counts in the amended information, I move to dismiss on personal jurisdiction grounds. The Court. All right. Mr. Kratz, is there anything further from the State with respect to that motion? Attorney Kratz. No, Judge. The Court has already ruled, as Mr. Strang has indicated, and will rely upon our argument on the previous findings of the Court. The Court. All right. For reasons previously stated by the Court will deny the defense motion. The Clerk's office informed me that there had been an interlocutory appeal filed on behalf of the defense today. I have not seen it, but I assume that the rationale for the defense motion is the subject of that appeal. But for purposes of the hearing today, the Court will deny the defense's motion to dismiss. I should also note, with respect to the amended information, while it adds 3 new counts, as counts 4, 5, and 6, I believe it also amends counts 1 and 2 to alleged party to the crime, rather than the simple offense in the original complaint. Mr. Strang, to those new charges, is the defendant prepared to enter a plea this morning? Attorney Strang. The defendant stands silent. The court. Okay, very well. Based on the defendant standing mute, the court will infer a plea on the defendant's behalf of not guilty to each of the 6 charges in the amended information. Now, the court has also received and agreed to hear today a motion on behalf of the defendant to extend the deadline for filing motions in this case, and also a motion to adjourn the trial. The motion itself contains some argument in support of those requests. Mr. Strang, does the defense have anything in addition to add at this time? Attorney Strang. Your Honor, the time that's intervened since I have filed this motion to extend, not quite 2 weeks ago, I guess, hasn't diminished in any way the basis for the motion. I still seek the relief that I have requested, namely a motion filing deadline applicable to both parties on or before June 16. Scheduling of a motion hearing at the convenience of the state and the Halbach family and the court and defense counsel, and a trial in 2007, sometime after the holidays and accommodating holiday obligations of the court and families and counsel. We're now at about 5,400 pages of discovery, give or take. The most recent search warrant executed by the state, I think, came the day I filed this. I think it was April 21st, thereabouts. I have received a copy of at least the hard drive of the principal evidence seized in that search warrant. I'm informed by counsel this morning as well that within about 10 days, give or take, the state will be in a position to provide crime lab reports relating to March 1 seizures to the defense. So I note that if counsel's estimate is good, as I expect it is, that we would be getting the crime lab, a large number of crime lab reports at about the time the provisional deadline for motions arrives, which is May 12th at the moment. I think as a matter of efficiency, it makes sense here or to try to avoid the piecemeal filing of motions. I realize others that motions in Limine will come much closer to a trial date. I realize, as well as the state's investigation may be going in this case, just as it is in almost any case. The state can't predict the course of future events any better than I can. That said, I think it makes sense to acquire what we have, that is, what the state has, look at it, and file some, as far as possible, one round of motions. June 16th, to enable the defense to do that. It is a tight timeline. This is not an issue on which I have asked for a mile, hoping to get a half mile. That is not my style or my practice in any event. I think June 16th is the minimum amount of time I reasonably need with Mr. Buting to meet my obligations to Mr. Avery under the 6th Amendment. I ask the court to do that as well. I think the September 5 trial date will not work, will not afford justice to the people of Wisconsin or to the man whose liberty here is at stake for the rest of his life, and will not assure that this court sees counsel perform as the 6th Amendment and this court demand. So I stand on earlier requests. I don't need to reiterate what I provided in writing, but that's what I can add. The court. And I understand, along with the requesting that the motion filing deadline be extended to that point, that the defendant is asking to have a June 16th as a deadline to notify the court whether or not the defendant wishes to pursue a change of venue motion as well. Attorney Strang. Yes, and I would propose to be bound by that. You know, at this point, I have straddled, in a sense. I have said, and because it's true, that the defense continues to prefer a Manitowoc County jury, If we can get an impartial jury from this county, I recognize the practical obstacles to that. I also appreciate that the court and the clerk of court have a good deal of administrative work to do if the venue is to be changed. In balancing all that, it strikes me as fair that the defense take a final position on that issue, and I see no reason not to couple that with the motion deadline, if the court will indulge our scheduling needs in that respect. The court. All right. Mr. Kratz? Attorney Kratz. Thank you, Judge. I have several points. First, this court, on the issue of motion extension, I believe necessarily needs to address the trial date issue first. In granting relief to the defense for moving the trial date past the current September 5th date, the court very well may then wish to similarly extend the motion date. Let me just tell the court that should the court be moving the trial date, I don't have any objection to Mr. Strang's request that the motions themselves be put off for an additional 5 weeks or so. As to the trial date, the state does not necessarily object to the September 5th date being moved, at least in some respect, given the crime lab analysis that has now been completed, at least now that, or what we have already submitted, we believe is completed. Mr. Strang is correct that we can't predict if there is going to be additional work in the future, but at least that what has been submitted has been completed. The reports are to be forwarded to Mr. Strang in the near future. In considering a motion for adjournment of the trial date, this court is required to consider the position not only of the parties, but also of the victim. Victim rights, Section 950.04, 1V, A, requires that court consider the victim's position. Victim in a homicide case extends to the surviving family members. I can tell the court that after explaining the realities of discovery, the realities of the effective assistance of counsel that Mr. Avery is entitled by Mr. Strang and Mr. Buting, that the family would not object to a continuance of the trial date past September 5th. I'm also authorized by the family to extend their request that the trial date be finished as soon as this court is able to realistically schedule that. The state has suggested to this court an October 16 start date, that is, jury selection to begin on the 16th. That would, with at least the timeline we have provided to the court, have us completed by, hopefully, the 17th of November, and certainly no later than the 22nd of November, which is before the Thanksgiving holiday. This would be an extension of time, I believe, sufficient for those reasons set forth in Mr. Strang's arguments to the court, as something certainly the state could be prepared for and could live with. And that is, in fact, my affirmative recommendation to the court that the trial date be set as a firm date beginning October 16th, with motions then to be filed by Mr. Strang and myself no later than the 16th of June. The court. Mr. Strang, anything with respect to the date of trial, could the court grant your request to extend the trial date from the current September date? Attorney Strang, October 16th surely would be better than September 5th, but I don't think it's adequate. It's better, but I think not sufficient. Again, the defense proposed 2007 because that's what we think is necessary to accommodate, for example, defense testing, if we need to, once we have got the crime lab results, to accommodate the exchange of expert witnesses, and just to get through the massive discovery here and do the necessary defense investigation. So I don't want to sound inflexible. Again, October 16th is better. It's an improvement on September 5th. It's not what I would prefer or I think we need. The court. All right. First of all, with respect to the request to extend the motions deadline, I think the information provided by the defense in the motion gives a number of reasons why an extension of the deadline for filing pretrial motions is appropriate. The volume of discovery in this case is significant, and as I understand it, the information that will be provided by the state to the defense has not yet to be completed, although it's expected to be completed in the near future. The court also recognizes that the case took somewhat of a different turn, if you will, by the filing of a complaint against an alleged co-defendant, and the defense legitimately wishes to monitor media reports to assess its request for a change of venue. For all of those reasons, the court believes that the request to extend the deadline for filing pretrial motions in this case is appropriate. I'm going to grant the defense motion to extend the deadline for filing pretrial motions in this case to June 16th of this year. I will ask the parties to include written argument in support of any motion they file with the filing of the motion. I will give the other party until June 26th to file any written response which they wish to file. And I would propose hearing the motions on Thursday, July 6th. Hopefully, you have got your calendars with you. Attorney Kratz: I am not available on the 6th, Judge, in fact. The court: what about the following week? Attorney Kratz: that is, I'm leaving on the 6th actually to be out of the state until the 14th. I would be available on the 5th. Certainly the week before would work as well. The court: what about the defense? Attorney Strang: the 5th is fine, the 6th is fine, the 10th is fine. The court should accommodate Mr. Kratz's schedule here so far as possible, and that we're the ones moving the motion deadline. The court: Mr. Kratz? Attorney Kratz: the 5th should be fine. The court: all right, let's set it for what time on the 5th? Attorney Strang: the sooner we can. It appears we would only have one day for that. The court: 9:30? 9? Attorney Strang: I think 9 o'clock would be most prudent. The court: all right, 9 o'clock on July 5th, and I will hold the day for motions on that day. Attorney Kratz: Judge, as we have informed the court before, Mr. Strang and I will make every effort before the 5th to discuss motions to be filed, and if we can reach some stipulations, we'll certainly alert the court of that on the 5th, or even before. The court: all right, thank you. Next, the court will take up the defendant's motion to adjourn the trial date in this case. That request is based on a number of considerations that are set forth in this motion. One of them relates to the effect of pretrial publicity. Needless to say, there has been a significant amount of pretrial publicity in this case, though I will note that the pace of media reports, at least, has slowed somewhat. There have been no press conferences or direct communication from the defense attorneys to the media recently, and the statements from both the victim's family and the defendant's family to the press also, fortunately, have settled down somewhat. In considering the request to adjourn the September trial date, I did take into consideration, and I am taking into consideration, all of the reasons offered by the defense for an adjournment. In that regard, the defense makes a number of supplemental requests. First, the court rule on the defendant's motion for March 8 for an order limiting public disclosure in this case. In evaluating this request, I cannot help but note a reference in the defendant's motion to what purports to be exculpatory DNA evidence regarding one of the items that was seized in this case. I think the example of the reference in this to the pleadings demonstrates the difficulty of effectively keeping either side from conveying evidentiary information to the media, even without direct communication. The applicable rule that governs the attorneys in this case is SCR 203.6. That rule provides in relevant part as follows. A lawyer shall not make an extrajudicial statement that a reasonable person would expect to be disseminated by means of public communication. If the lawyer knows or reasonably should know that it will have a substantial likelihood of materially prejudice. If the lawyer knows or reasonably should know that it will have a substantial likelihood of materially prejudicing the adjudicative proceeding in the matter. The rule goes on to provide that a statement referred to in paragraph A ordinarily is likely to have such an effect when it refers to a criminal matter and the statement relates to, among other things, the results of any examination or test, or the identity or nature of physical evidence expected to be presented. So the reference in the pleading, in this case, had it been directly communicated to the media, would have been within the prohibition of the rule. For that reason, the reference in the motion was, at least technically, not in violation of the rule. However, in the court's opinion, the reference was not really necessary to support the motion in this case, and it was placed in a pleading, which by now both parties are well aware the media regularly reviews in this case. Therefore, the court concludes it's somewhat disingenuous for the defense to ask this court to impose a gag order on the attorneys, but disseminate information to the press indirectly through a pleading where its inclusion, for argumentative purposes, the court believes is somewhat marginal. My criticism in this regard is not limited to the most recent example in this pleading. I am not at all sure that the press conference that was held when the charges were filed against Mr. Dassey was limited and certainly could have had an adverse effect on selecting a jury in this case. And I will note that when I listened to one of the press reports referring to the information contained in the defendant's motion, the news reporter reported that the state had no response at this time, but would reserve the right to respond to the press at a later date. Mr. Kratz, I have no direct information of anything you told the media, but I will note that I don't believe within the context of rule that if that report was accurate, that there could be a direct response to the press for something that was contained in a pleading. I'm not attempting here today really to jump down on either of you because I think each of you are trying to comply with the rules and allow an impartial jury to be selected. However, I think that what's taken place here serves as an example that even if the court did issue a gag order, in this case on the attorneys, it would not prove especially effective. So, since the court has been requested to rule on the motion for an order limiting public disclosure, I'm going to rule on that motion at this time, and I'm going to deny the motion for a number of reasons. First, the granting of such a motion is highly unusual and difficult to police. The court has not, in this case, seen behavior on either side so egregious that in the court's opinion it warranted a gag order. Secondly, the court is satisfied if the parties religiously adhere to pleas with SCR 23.6. That rule will provide adequate safeguards in this case. And third, as the reference in the defendant's pleading demonstrates, the court is not really satisfied that issuing a gag order would provide the complete protection that the court might hope to gain by issuing an order. So I'm going to deny the defense motion for an order limiting public disclosure. The defense also asked the court strictly enforce SCR Chapter 61 as to the media. Actually, Mr. Strang, I wasn't exactly sure what you were driving at there. I reviewed SCR 61 again. I have not really noted, in this case, any violations to the media. I have been communicating with the media through the media coordinator, and to the best of my knowledge, they have complied with all my KR-SZ, and I think we're operating under SCR 61. Is there anything specific you had in mind? Attorney Strang: the only ongoing problem of which I'm aware, it arises with streaming video on at least one of the television websites, and probably more than one, although I don't know that, and that's with the camera running when Your Honor is not on the bench. And that, as I read Chapter 61, that is not allowed. I think that after the court raised this at the joint request of the parties in March, I think that zooming in on either counsel table has stopped. At least I haven't noticed anything more like that. The court: all right. I did, following our discussion, convey a written instruction to the media through the media coordinator. I believe, to the best of my knowledge at this point, unless I receive a report otherwise, that those instructions are being complied with. The court has also been requested to keep motions in limine, seeking admission or inclusion of sensitive evidence, filed under seal. The motions in limine themselves, as noted by the parties, will be filed at a later date, closer to the trial. But I do agree that motions by the parties that are due now by June 16th, which could include a motion for either party to admit other acts of evidence, could prove prejudicial and make it more difficult to select a fair and impartial jury. So I am going to order that any motions seeking other acts of evidence that are filed by June 16th be filed under seal. I ask the parties to differentiate those motions, put them in separate document than your other motions. Include any written argument in favor of your request with the motion, and whether or not the court releases them from being kept under seal, I will make that determination after I review them. Mr. Kratz, is there anything you wish to raise regarding that? Attorney Kratz: no, Judge. The other acts motion, we were just going to point out, as Mr. Strang and I had discussed, and I believe it was outside the court's presence, that the concern is any motions that may require the court to balance a prejudicial effect versus probative value. Those wouldn't be limited to the character type evidence or other acts evidence, but could include other kinds of motions in limine where we seek advanced rulings of the court where that analysis that is to be made. Those are the kinds of sensitive material and motions that perhaps the court is already envisioning to be filed outside of the public domain, and then the court can rule on dissemination thereafter. The court: I know the parties have previously agreed to, informally at least, exchange motions with each other before they are filed, and certainly I ask that you do that. If either of you have any motions you see are going to be filed by the other side that you file should also fall within the court's order, we can conduct a telephone conference ahead of time. You can notify me of those ahead of time, and I would make a determination. The court is also, or the defense also asks the court to reconsider the court's motion denying modification of bail. I wouldn't take such action unless a formal motion was made to that effect, but I will simply state at this time, I think I have addressed that issue previously on the record, and I'm not aware of any information that would cause the court to reconsider the decision that's already been made. With those considerations in mind, the court has been asked to adjourn the trial date. With respect to the trial date, first of all, I agree, and I don't really hear the state to be seriously disputing it, that an adjournment trial date from the early September date is called for in this case. The case not only involves voluminous discovery, but there's been a second round of it related to a subsequent investigation by the state. I think the defense, which to this point hasn't received all of the lab results from the state, is entitled to adequate time in order to assess the results of the state's investigation, to evaluate those results, and to determine whether or not the defense wishes to conduct additional testing on its own. That takes time, and that, I believe, the time that's required would be pushing it, at least if we stuck with the September trial date. I do feel that there are countervailing reasons for holding the trial promptly. People's memories tend to fade. Both parties are entitled to a trial that is held as soon as it can be reasonably held, given the parties an opportunity to prepare. I believe in this case it's most appropriate to adjourn the trial date in this case to Monday, October 16th. I believe that has a number of advantages. First of all, that means it would take place more than 5 months from today. I think that would allow dissipation of any adverse publicity there might have taken place already. It gives the party an adequate chance to prepare, and yet it does not unduly delay the trial in this case. By starting it on October 16, I think it can be completed before the Thanksgiving holiday, and for those reasons, I think that's an appropriate delay. I haven't heard anything specific that would call on the court to consider a delay longer than that. So I'm going to delay the start of trial until Monday, October 16th. Is there anything else that either party wishes the court to take up this morning? Attorney Kratz. Mr. Strang, with that new trial date, had previously discussed with me an exchange of experts and a more detailed scheduling order regarding some more detailed discovery matters. May I suggest, Judge, that the court allow Mr. Strang and I to try to resolve those matters and report to the court within our correspondence by June 16th as to our discussion as to exchange of experts and the like, and other kinds of scheduling matters, and then should we need acquiescence or approval of the court, that we can seek that sometime after the 16th. The court. All right. Mr. Strang, Attorney Strang. That makes sense, and I further will take an implicit and consider myself bound by a June 16 deadline for making a final decision on change of venue. The court. Yes. Attorney Strang. Barring something really unforeseen happening. The court. I meant to include that in your order. Yes, you can consider that included. And at this point, I haven't specifically addressed an additional scheduling order to deal with matters before the trial. I certainly anticipate that there will be one. I appreciate the fact that the attorneys will be talking with each other and attempt to present the court with joint recommendations on dates. But there will be a date, for example, for filing motions in Lamine and that type of thing before the trial. Anything else this morning? Attorney Kratz. Not by the state judge. Attorney Strang. Nothing here either. The court. All right. If not, the court will prepare an order reflecting the court's decision this morning on the motions. And with that, we're adjourned for today. Attorney Kratz. Thank you, Judge. The court. The clerk just reminded me of something. The May 18 and 19 dates that have been held for hearing, the motions which were due on May 1st, the hearing on those dates are canceled. Attorney Kratz. Thank you, Judge. Attorney Fallon. Thank you. Proceedings concluded.